Blog Talk Radio.
He is the last of his kind. All that remains of a once powerful nation. Some think he is a myth. Some believe he is the chosen one, who will bring balance to a world at war. And some will stop at nothing to destroy him.
Welcome, Moorish to Moorish Talk Live 100. I'm your host, Tarhaka Black, and tonight we'll be dealing with part 2 of setting up trust using the private. Now, I have to say that I apologize for part 1. We had some tornadoes blowing through here that Sunday, and I guess most of you all already know the devastation of what happened, but I did let everybody know up front in the event, and it was looking good, but all of a sudden, boom, we got hit. So we lost a lot of very important information in part 1, so I'm going to do my best to bring that back to table in part 2. And then we'll be coming back, and as we go along, we'll be doing bringing other information involving your trust and operating in the private, okay? I'm going to go to the commercials, and when we come back, we'll be ready to go in, okay? So y'all just hold on a moment, and we'll be ready to go.
Still, one of the biggest problems facing people in this country today is debt. The election of a new president doesn't mean your debt will go away. For student loan, child support, mortgage, foreclosure, credit card debt, etc., contact me, Tarhaka Black, 904-303-9061 before 7 p.m. Eastern Standard Time, or visit newdebtelimination.com. You need to get out of debt now. Send for my free report by clicking on the Contact Us page at newdebtelimination.com. Fill it out, and I'll send my free report straight to your email address. Okay? That's www.newdebtelimination.com. Contact me directly, 904-303-9061, about solutions to the problems of debt. How to be a secured party. Freedom means everything, but what will you do when you get free? Do you just want to be left alone? Will you remain stagnate, or are you willing to delegate? Go to www.newdebtelimination.com. That's www.newdebtelimination.com. Or call me, Tarhaka Black, 904-303-9061 before 7 p.m. Eastern Standard Time. That's 904-303-9061 before 7 p.m. Eastern Standard Time. Let's move into the realm of the secured party, and let's take advantage of what it means to be a creditor inside the United States of America. The person you want to talk to about beating foreclosure or mortgages are exercising your freedom of right to travel is someone who has already done it and can provide you with proof that they have done it, right? Go to www.newdebtelimination.com. That's www.newdebtelimination.com. Call me, Tarhaka Amana L. Bay. Contact me directly, area code 904-303-9061. 904-303-9061. The person you want to talk to is the person who have done it. If you got problems with credit card debt, student loan, child support, you name it, contact me, Tarhaka Amana L. Bay, 904-303-9061. Go to www.newdebtelimination.com.
Okay, we back. Now, let's go back over some of the stuff that we discussed in part one. First of all, what is a trust? Okay, let's clearly define what we're dealing with. A trust is a relationship with respect to property involving three players. All right, it's commonly referred to as the settlor, or grantor, a truster, a donor, or the maker of a trust. Now, the settlor, grantor, truster, donor, or the maker is the person who transfers property into the trust. All right? It is the person who transfers property into the trust. Now, sometimes they are referred to as transferors. So when you hear that word, that's the original grantor. Okay. The next player is the trustee. Now, the trustee is given legal title to the property. Job is to hold and manage the property in accordance with the instructions in the trust. Now, when the grantor creates the trust, what he does is he creates a series of documents or declaration of what is in that trust and the duties, responsibility, and property, and what goes to the third players, which are the beneficiaries. Now, they are the ones that's managing the trust. Okay, the trustees are the one that actually manages the trust. Okay, and we're going to get down so you can understand the mechanics of this and see how it works out for people. Now, the third player, once again, is the beneficiaries. Now, the beneficiary is given the benefit of the property that is an equitable interest in the property. Okay, these are the ones that inherit the property that's held in trust and managed by the trustees. So, as you can see, with this kind of setup, it's very important for you to have what? Trust. You're going to have to, in order to create this and make this work for you, everybody needs to be on the same page. The grantor and the trustees need to be on the same page. The beneficiary needs to understand what this is. Now, there are different types of trust, like we discussed in part one. We got things called blind trust. We got trust where the beneficiaries don't even know that a trust has been set up that they can benefit from. And so it depends on what kind of trust you're structuring. You know the beneficiaries, 9 times out of 10, is your children. And you know who will do what and under what circumstances and all of this stuff here. So you know pretty much how to do this thing. Okay, let's look at an example. We'll say James transfers $1 million and his farm, a Blackshire, to Teresa, instructing Teresa to invest the money and to rent out Blackshire with an investment income and rent proceeds to be paid to Bonnie for life. At Bonnie's death, the remaining property in the trust, including Blackshire, is to be transferred to Benjamin. Okay, all right. Samuel is the settler. The trust property is $1 million and Blackshire. All right. Now, Teresa is the trustee, and she owns a fiduciary duty to both the beneficiaries. Bonnie is the income or life beneficiary. Benjamin is the principal or remainder beneficiary. So you can see this is how a trust basically functions. And we're going to get down into the benefits of setting up a trust this way. For instance, I'll give you a little quick example. We'll say that you own a business, you put that business in trust. You own some property that's to be inherited by the beneficiaries, but you got someone managing the trust with instructions. All of those are included in the trust, the indentures, the declaration of trust, all of this stuff is included in there. And keep in mind, way back when, I told you everything in America operates on contract. But we're going to say that some kind of way someone was injured on the property. So who are they going to sue? They can't sue the grantor because the grantor don't own the building. He doesn't own the property. The property is held in trust. You see. So this protects the grantor because he has set this up. But we're gonna see how this thing plays out. Okay. Let's look at types of trust. We got express trust, implied trust, resulting trust, constructive trust. There are many different types of trust. Irrevocable trust, revocable trust, different types. But let's take a look at what the law says about creating trust, okay? In Burnett versus Smith, 240 SW 1004, 1922, the court stated, a pure contract trust is established by contract, and any laws or procedure in its operation denying or obstructing contract rights impairs contract obligation and is therefore violating of the United States Constitution. Okay? And in Berry versus McCourt, number 204 NE 2D 235, 1965, the court stated, a pure contract trust is a constructual relationship in trust form. And in Crocker versus McCoy, MACCOY, 649 U.S. SUPP 39 at 270, the court stated, a trust organization created under the United States Constitution right of contract cannot be abridged. Okay, so as you can see, the structure of a trust is very important. Now, before we go any further into this, because we got quite a bit of information to bring to the table involving this trust, its structure, and because this is the first thing that you want to set up. You know, we got a lot of people trying to do a lot of things. A lot of people, I talk to them, they say, well, you know, I filed my UCC, and I did my declaration, and I did my birth certificate, and that, all that's great. But what we're talking about now is we're talking about setting up a structure, and this is what wealthy people do all across the country and around the world. They understand trust law. They set up trust, and which removes all the shackles and burdens from them, which would otherwise hinder them if they had not been that way. You can also set up a private trust, a charitable trust, a testamentary trust, a living trust, ecclesiastical trust, a common law trust. And the common law, in my opinion, one of the most powerful trusts to be established is a common law trust. Okay, and we're going to go over that a little bit as well. But I just wanted to bring this information out so we'll have the basics about what we are doing here when it comes to dealing with trust. Keep in mind that once again on the 28th of this month, which is the last Sunday in this month, we're going to have Dr. Walter Williams, who will be our guest, And if I'm not mistaken, I think, now I'm not sure, I think that's going to be on Super Bowl night. But none of that appeals to me. I don't have any time for games. That's for, I just, don't have any time for that. But anyway, that'll be, I'm sorry, talking about the 28th. That's going to be the 29th of this month. That's the last Sunday in this month. Myself and Dr. Walter Williams will be with us, and we'll be discussing our next topic in relationship to this religion and stuff. Okay, because this is still got people going with this thing. They have not understood that they are spiritual beings having a human existence, and they don't understand that it has absolutely nothing to do with religion, and they're refusing to understand that it is all a part of the global system of white supremacy. And so I'm able to, and we're not talking about hating anybody, anything like that. I'm able to listen to someone, a Christian, a person who knows trust, and I can explain trust and is using trust successfully. I'm able to listen to what they have to say about that. It doesn't bother me because I know the truth in regards to religion. You understand what I'm saying? Okay. But anyway, let's go on to the next thing here, because we're trying to get up to speed on what we missed out on in part one. Now, in part one, we was talking about what was commonly referred to as a U-bot, but which is in reality an irrevocable common law trust. Okay, but we're going to look at the Declaration of Trust and how it is set up, so which will give you a gist of your declaration, your trust declaration. Declaration of Trust. This contract and declaration between the undersigned parties, known hereafter as the creator or grantor or the exchanger, agree to whit. Creator herein offers for consideration to create an organization under the common law having a fixed number of certificates with evidence a right distribution, commonly known as a pure trust organization or unincorporated business organization. And two, exchanger herein agrees to the exchange and trade good and valuable consideration for certificates of the newly created organization. Therefore, the parties mutually agree, promise and covenant as follows. Number one, consideration. Exchanger herein agrees to bargain, exchange, assign, convey, and deliver to this organization or its appointed trustee a promissory note payable upon demand for $21 denominated in the United States silver certificates or tangible coin, plus other good and valuable considerations in exchange for 005 certificates, evidencing a right of distribution as promised by Creator. Immediately upon execution of this agreement, Creator agrees to appoint a trustee having the authority to carry out the exchange and hold an administrative consideration received. This initial exchange, a description of the consideration, whether personal and a real property, and the number of certificates issued shall be documented in the minutes of the organization. Both parties herein contract to perform and agree that this exchange is not a sale or a gift, but an equal in value exchange. Okay, so we have basic trust being constructed between two parties, the grantor or creator of the trust and the trustee, the one who's going to administer and carry out the duties of the trust. Your trustee can be assigned to purchase certain properties. Now, he's protected because he is following orders of the grantor, but the whole system is wrapped in trust for the benefit of who? The beneficiaries. Okay, because this is all of this is on contract, and once we understand that, the way it works is on contract. Okay. Now, before I go into any more on the Declaration of Trust, I want to give us a little bit of background on what makes this thing so important. And this is for people who have been thinking about, well, I want to be a secured party, and I want to be a secured party creditor, which is, in my opinion, no such thing. Being a secured party means you got all the knowledge and actions, and you know that you are secure. Okay, and then next thing you want to have a little bit of verifiable proof and put your little documents down on contract, and which matches your performance, okay, and your actions in real life. Now, the next thing is the creditor part, and that's when you are actually operating in the private. You're carrying out the structure of your trust. You're doing what belongs in the private, opposed to what you had previously been doing in the public. Okay. Now I want to bring you up to speed on a little information on this, so that we can clearly get a little bit clearer understanding about what I'm talking about when we're talking about trust. Okay. The greatest deterrent to putting assets in an irrevocable trust is giving up control. This chapter gives you an entirely different perspective about ownership. A lot of people think that I want to own this. We're going to take a look at that, owning something versus not owning it, but controlling everything. You see, the rich, they don't want to own nothing. They know the game. I don't own this. This is owned, held in trust. I'm just a grantor. You can't come after me. I own that. Okay, I owe you no taxes because I own that. All right. Getting the goods of the world can be a wonderful experience. Further structuring your stuff is ways ranging from subtle to blatant. Is considered proper, laudable, or even mandatory. Being the Joneses instead of trying to keep up with them is often a secret wish. It means being in control of your life instead of at the mercy of others. Is this an illusion? Whether it be a shopping spree, a new car, or getting a mortgage for a home, the less to have is considered normal. But is it? Let's take a look. There's a different way to look at ownership. As a lawyer told us, the only reason they let you have anything at all is so if you do not obey, it can be taken away from you. What? You do not believe it? If you do not pay your income taxes, you can lose your home, your car, and anything else the IRS decides it wants to place a lien against. If you do not pay your county property taxes, your home disappears into the black hole of forfeiture. As a homeowner, you live with the threat, that constant reminder that if you step out of line, it may cost you everything. Lose your job, become involved in an unfortunate divorce, and all of your hard-earned equity in the property can be claimed by the ex-spouse, the bank, the state, or the IRS. You owned it. You lose it. In fact, if you ask people around you about the state of affairs of their finances, you will probably discover some of them have lost at one time or another. They've already lost it. Because we have this thing in our mind that I want to own my home, free and clear. This is the thing, and I mean it's normal for people to think that way. We want to have something. However, the best way to do it instead of owning it is to control it, and this is why we're discussing trust tonight. Here's another hard truth. According to a friend of ours who became closely associated with an ex-judge, the judge told her people never own their home. That is why the state can take it when they do not pay their property taxes. Property only belongs to the state, never to the individual. We would like to give you a footnote on that, but for the safety of the judge, we cannot. We quote it here, though, because we have heard several times, and even from a real estate agent. We met at a spa while we were steaming in the mineral bath. In the astounding confession, they reveal this fact to several others in that pool. Some homeowners flatly did not believe and others were so shocked that they fled the pool in dismay. A hint, the statement is true, is found in the definition of land held in allodial. You might want to type that in. Land held in allodial title. Free, not holden, of any lord or superior, owned without obligation of the vestiges or fealty. The opposite of feudal. Do you own your home in allodial title? No, you own it in fee simple. Although these people who shared their knowledge about the true ownership statute of property must remain unknown, we can send you to any law dictionary to look up the term fee simple. Property transferred in fee simple allows it to be inherited, not owned. You may wonder what the mysterious difference is between allodial title and fee simple. By answering a few questions and learning some obscure history, you can more fully understand. Do you want to pay for all the benefits of the county services? We mean, do you want to dig your own water well, simply own your electricity, providing your own fire and police protection? Probably not. Therefore, when you elect to pay county taxes, you also forfeit full ownership of your property. Obviously, a allodial title is not unless you are ultra rich. Fee simple is for you. This state-owned property fact is becoming more and more known, and if you ask around, it will be revealed to you by those who know. Why ownership can be bad. Let's take a look at that. Taking the responsibility to pay off a home loan or to buy a car or installment payments is something of which to be proud. We agree, except in the current corrupt climate of government and tax organizations. Ownership could be a greater liability than most people realize. The politically savvy kings of ancient times know all about this. They bridged the ordinary person by offering him a title and some land if he served in the king's army. As a bonus, he would see exotic foreign countries and fight in hard-won glory in distant battles. There was always, though, that sly little royal trick. For a commoner now, a knight, to hold the land took an army. And without the strength to battle raiding bands of the encroaching nations, this new title, fiefdom, was doomed. Now that same honorable knight must ask the clever king for help to defend his tiny plot of land and his family. For that he has to pay a price. Whatever the price was, it involved some pledge that enslaved him to both king and land, and that hard-earned title became tainted with a different noble slavery. The serf of the land may have had a better arrangement than the helpless knight, obligated laden with responsibilities and political schemes that complicated his life. Although this paints a dark picture, and it perhaps dramatic to make the point, ownership can be leverage others use against you. If you take this leverage out of your hands, out of the hands of others, could you find a new freedom? But you argue that without the mortgage, you would not have the present equity in your home against which you could borrow. Delighted that it turned out to be a forced savings program, you believed it is a blessing to you. Not only were you lucky that you did not lose your home, but fortunate that you brought it where and when the real estate prices increased. Maybe you even paid off your home. Continue to pay your taxes on time and spend enough funds for home improvements and repairs. This is the upside of your dream. But would you like to keep that home in the family? Or perhaps would you like to use your amassed equity in some way to benefit your family members? Why use is better than ownership. Ownership is stranger than fiction. If you form an irrevocable trust and transfer assets into it, such as a residential property, the ownership becomes split. The beneficiaries have equitable interests, and the trustees hold legal title. Now recorded at the county, the residential property is owned by the trust, and the trustees' names are listed as responsible parties. As mentioned in a previous chapter, this is known in law as divided title, and no one actually owns the asset. The trustees are legally responsible for the assets in the trust and take care of it, but only hold it for the benefit of the beneficiaries. A trust removes direct ownership. It takes money and property out of your hands where it can be used against you. Now in the hands of people removed from the direct involvement in the enterprises, legal and financial complications are less likely. Property is safer. I'm going to stop right there. We're going to come back and deal with this right here a little bit more, because this gives us a concise breakdown on why it is important for you to set your trust up and to hold your assets in trust. And we got quite a bit of information, but we're going to go back over here and do a little bit more update on what we did not get a hold of in part one. Administered as trust estate. Okay, we're still dealing with the declaration of trust here. Assets of this organization shall be deemed for administrative purposes. A trust estate and the consideration received from the exchanger shall be deemed the initial corpus. Any additional property received from any future exchanger or any party shall be deemed an additional corpus. Any person may add property of any character to the trust estate at any time by gift, grant, conveyance, exchange, insurance proceeds, assignment, will, or any other method, so long as the property and method of transfer is approved by the trustee. All assets belonging to the trust estate shall be listed on Schedule A. Now, Schedule A is a sheet where you just simply list all of the assets that's a part of the trust, or an addendum to Schedule A, and administrators provided herein. Okay. Now, what we're dealing with now is the actual declaration of trust, which is a document that goes along with the trust. Okay. Then you, and this is in the declaration here, the irrevocable agreement, and then after that, the appointment of trustees, board of trustees. All this information is recorded in the original declaration of your trust when you set it up. Okay. Irrevocable agreement states the following: the parties herein agree that this contract and declaration, including all trust provisions contained herein, shall be irrevocable. Exchanger irrevocably relinquishes all rights to the property exchanged into this organization. Neither creator nor exchanger nor any certificate holder shall have any right to revoke or amend this contract and declaration. Amendments may only be made by unanimous approval of the Board of Trustees as provided herein. Further, the Board of Trustees shall have exclusive power to construe and determine the meaning and intent of this contract and its declaration. Okay, appointment of trustee. Upon execution of this contract and declaration, the creator shall appoint a trustee known hereafter as the first trustee to administer the organization as provided herein. The first trustee shall provide creator a written acceptance of the appointment, which shall be made as a part of the permanent records. Okay, now when you assign your trustees, you're going to send him a letter, and because this is, all of this stuff has to be added to the documentation when you're setting up a trust. So you simply send him a letter. You can send it to him certified mail, offering him appointment to be first trustee, and with instructions to either accept or reject, but send that letter back to you, certified mail or registered mail with return receipt or what have you. Okay, now we got these letters to add to your declaration of trust, clearly showing that you have abided by the rules and regulations and guidelines when it comes to appointing a trustee to your trust. Board of Trustees, let's go there. The first trustee, upon acceptance of appointment, may thereafter appoint a second trustee. They, in turn, may jointly appoint one or more additional trustees and may designate successors. Trustees shall collectively act by authority of this contract and the trust provisions contained herein. Okay, so you see how this thing is going now? Okay, now remember what the trustee's job is. Their job is to manage the trust. You created the trust. You got somebody else orchestrating the trust in the assets of the trust. You may say, well, okay, I'm going to purchase a home. We're gonna buy a home. We're gonna fix it up. We're going to add it to the trust, and we're going to notify the trustees that their job is to make sure that the property remains intact. If there's fund needed, the trustees need to notify the grantor. If there's tenants that got to be put in, the trustees going to orchestrate that because that's what? Property held in trust on behalf of the who? Beneficiaries. Okay. And I know by now we should be understanding how this thing goes. And we're going to go on some more with this, but I want to go to a little plug here, and so you guys can hear how this thing goes involving your secured party, because in part one we dealt with these guys actually discussing this in a seminar. So I want to bring part two that we did not put up in part one, and we're going to come back and continue with this declaration of trust so you can see how it functions. See, so you don't just do the declaration of trust and just put it up and say, well, I got my declaration of trust done. Okay, well, how is this thing functioning? How does it operate? What are you doing? Do you know what you're doing with this thing, or do you just have a declaration of trust set up and you ain't doing nothing with it? I mean, it's not working. It's not functional. Okay, so this is what I'm trying to get you to understand about a trust. You want to orchestrate the trust. The trust is, if it is expressed, then it needs to be moving. If you got an express train or express bus, it's in motion. Okay, so let's go to this plug, and when we come back, we're going to take up where we left off with your declaration of trust. So y'all hold on a second, okay?
These Creditors in Commerce workshop sessions, hereinafter sessions, are the private.
Well, this is Tim's process. So if you're going to do Tim's process, you would have the power of attorney, the notice and demand, indemnity bond and lien, hold harmless. I want to know from you, now that we've established the relationship between the two trusts, what could be next? Couldn't we go straight to the UCC one? A notice? Because with the commercial security agreement, we established the lien. A security agreement is a lien. That's a documentary lien. Then the notice of lien would be the UCC one. And there's also samples of that on there. He does a Baylor-Bailey type filing. Okay?
Which is still different than yours.
It is different than mine.
He's still using transmitting authority.
Yeah, he still does it totally different than me. I'm not going to say what's right or wrong. I could probably walk in either role, but I've actually got probably 5 or 6 UCC ones.
Are you still standing on the same way to file it as you did back in, what was that, February of 2009?
That's one way that I've still got that one filed. Because what you should read, go look up, and if you look online, they have a legal encyclopedia that gives a really good in-depth definition and breakdown of bailment. Actually, I think I provided it in that class, right? Okay, so what was that, private public records? Episode 3?
It's 24, I don't
Okay. I think it's the private public records from the Living Temple, and it has, a breakdown of what bailment is. And in bailment, you have 2 parties, a bailee and a bailor. Now let me give you an example of a bailment agreement. How many of you valeted your cars today? Am I the only idiot who valets their car?
It's not just valet. If you park in the lot, it does the same thing. They got a bailment too.
Oh, right. So you did, okay. So we parked in the lot.
Either way.
But I actually have a specific trustee I can hold responsible, right? I've got, now who's the bailor, who's the bailee? I'm the bailor. What does the bailor do? Puts property into the hands of the bailee.
Their trust. Their trust.
So the bailee is what's his role in the trust? A trustee. So as trustee, what's his interest now? He's got the paramount security interest. He's got the controlling interest in that vehicle. Until the bailor comes a calling. Right? So I could support either role. Let's look at it this way. Public trust puts all of its property into trust to be managed by the private trust. That would be public trust bailor, private trust bailee. However, what's the private trust got? An exemption. So couldn't the private trust put its property into trust to be managed by the public trust? In either case, you're the trustee on both trusts. So bailor, bailee, it's basically trustor, trustee. Where the bailee is the one who's controlling the property.
But he isn't the real party of interest.
No. Okay? So I almost see, I think I might come up with a whole different filing on that altogether. That's not bailor, bailee. I do like the secured party debtor one because it's pretty clear and straightforward. We know the public trust is the debtor because all it uses up the private trust's assets. So it's indebted to the private trust, right? So the private trust has been acting as trustee in my trust for 36 years. I haven't been compensated once. I'm going to file a claim. Actually, I already got one. I actually got like 5 or 6 of them.
So just for clarification purposes, bailor, bailee, I pull in the valet parking with my $300,000 Ferrari.
Mm-hmm.
I give it to the valet.
Mm-hmm.
He goes off and takes it for a joyride and just has a wonderful good time. Doesn't hurt anyone.
Ferris Bueller's Day Off.
Yeah, exactly. I come out to get it. He's back. I've authorized him to do that. In other words, tacitly? I mean, if he is...
Hold on. Let me read the terms of my agreement. This contract limits our liability. Oh, no. Customer and company agree as follows. Customer agrees to inspect car before leaving lot. Customer's claim of damage or loss must be reported and itemized in writing on company's form before car is taken from the auto park following a claim or loss. And if not so made, any such claim is waived by customer. Waiver clause. Should company agree to make repairs to customer's car, should they agree, at its expense, company has option within 48 hours after filing of claim to choose the place in person to make the repairs. Court actions by customer for any claims must be filed within 90 days from date of parking when alleged damage occurred, in court of jurisdiction where claimed loss occurred. In all court actions, the burden of proof to establish claim remains with customer. Company is not responsible for damage by fire or defective brakes or parts. Company not responsible for any article left in car, including, but not limited to, CB radios, radar detectors, antennas, tape decks, tape cartridges, pull-out radios, and cellular telephones. Nor will company accept possession or bailment, right there in the contract, of such articles. Attendant has no authority to bind company or create bailment for any such articles. Company is not responsible for cars after closing time as posted at lot. Any car keys left with company must be picked up by customer prior to closing time. Customer must set brake before leaving car. Company not responsible for loss of use. This contract is not assignable. This is the entire contract and no employee can modify it. Customer waives all rights in conflict with the foregoing.
So I could cross out anything I want in there.
Conditionally accept?
Yeah.
But what do they do? No. What do they do? How do you get this ticket?
You have to hand it to them to get your car.
They rip off a piece of it, right? And they hand it to you.
And I accept.
You accepted it. Give me back my car. So, Do you see that's how contract works? What is the Canadian guy? What's his name?
Robert Menard.
Yeah, Robert Menard. What's he call him? Shove it. He's got a word for it. When they're sliding you documents, you slide them back. So, alrighty. So, we've got the essence of the secured party creditor. Basically, establish a private record of your claim. It can be in any form. It could be a bailment contract. It could be a security agreement. It could be a claim you do against yourself, like literally even mail it to yourself, do notice of default. Well, not against yourself, but your private trust against your public trust, right? Is doing a claim, mailing it. You might want to have two addresses, one for the private trust, one for the public trust, right? And mail everything. Get your certificate of service, your certificate of non-response. Now you've got a claim. Even more solid. And you could do it all up, like do the monster claim like I was talking about with all your evidence and your security, your tracer flag on there. Now you probably don't want to cash that one in because it's going to liquidate your other trust. But you've got the claim. And that's the foundation for any and all notices that you file. So, in essence, secured party creditor is and needs no documentary proof of such. Your conduct, your use of language, that's what makes you the secured party creditor. Now, having the documentary evidence is definitely beneficial, especially for those not as versed. But you're more likely to be challenged more rigorously when you put up these documents, because they're going to really test you. If you talk and you sound like you know what you're talking about, they may just say, yeah, I might not want to mess with this one. But if all you do is hand them a stack of documents and go, I'm a secured party creditor. You can't touch me. I'm immune. You can't write me a speeding ticket. Right there, you've confused yourself with who you really are. Well, are you the executive trustee or are you the public trust? We didn't write you a ticket. And that's actually one of the flaws I've pointed out to Tim twice in his own documents, so be aware of this. We're not going to go over those documents till tomorrow, but his claim documents, he says right in the claim document, you, like as part of his counterclaim, you must discharge or dismiss with prejudice all claims against me. Instead of the defendant or the public trust. Hello, Tim, they don't have a claim against you, right? They have a claim against the public trust. Yeah. I will get him to correct that in his documents, though. I've been to 2 of his seminars, and I had to point it out both times. I'm all, Tim, you got me here in more than one spot that I wouldn't put me. So be mindful of that. No one's process is perfect. No one's process is perfect. In fact, you should look at every process as not only a tool to learn from, but something to improve upon. Become a PhD in commerce. You know what a PhD has to do to get a PhD? He has to add to the body of work. He has to make his discipline richer than it was. Right? Yeah, he has to make it richer. It has to be something greater than it was before he got his PhD. Right? He's got to get published. Now, I'm not saying you got to get published, but definitely put it together in such a way that it makes sense to you. And you can connect all the dots and you can line up all the pieces and it all fits. Okay? Make sure that what you're doing has a line of reasoning and logic for you. Think about what you're doing. Do not ever blindly fill out someone's documents by just putting your name in it. If you don't understand it, don't file it. Don't execute it. Don't mail it. That's going to get you into more trouble than anything. Exactly. It's not your document. And you guys, trust me, When they get 10,000 of a doc, like I had to recreate all of my processes because everybody's using my processes. They don't even look like my processes anymore. They think I'm just another Yahoo downloading stuff off the internet. And I'm the one who created it. And I just keep giving it away, so it's not like it's ever going to change, but that's, you know, that's part of the creating from something. You know, I still study. I just told you, I just went to a Tim Turner seminar. And the next time I'm available and Winston does one, I'm going to go to the next Winston one. I'm going to miss that one. I'm going to be in Atlanta at the time, so I didn't realize we had one on the same weekend.
What about Victoria Joy?
I haven't been to a Victoria Joy yet. I'm anxious to go to one. I just haven't been to one yet. But I think that's where we get the law form model. You know, the 5 law forms. I think that came from Victoria Joy. I'm not positive.
By the way, Tim is up in Vegas this weekend teaching the international enforcement part of it.
International enforcement.
The international through the maritime lien. Okay,
yeah.
So that's what he's doing this weekend. And John and Diane and a couple of other people, CW, are up there. This is the subject matter of that enforcement.
Perfect. So, I think, any other questions regarding secured party creditor, anything specific dealing with these particular documents? I can go into detail about any of these. If it's not evident to you what they are by the name, like I said, I've given you what I feel, and this is just my personal process. I haven't done all these documents. I don't see a need because I clearly define the roles in the trust. If the private trust is the trustee of the public trust and I'm the trustee of the private trust, I've already established most of these things.
You don't do a property list?
I do a property list. I do the commercial security agreement and the property list just because it's really, that's my trust document. You know, it's restructuring the public trust in case there's any presumptions about the property in the trust. Right? We want to rebut the presumption that somebody else has an interest in the property. And the way the property list is written out, he lists all the essential elements of the public trust, from birth certificate with the birth certificate number, social security card with the number and the bond number, everything you could possibly think of that makes up the public trust is on there. And I actually use that for also establishing how people grant their property into my trust, because I actually have a separate trust, a separate private trust from my other private trust. And that private trust, people grant and convey their interest into, and then I walk in representing the interest of the trust. You assign your property to my trust. Well, now it's my duty as the trustee to discharge any debts, right, for your public trust. Because now I'm the trustee of your public trust. So I must answer for your public trust. You see? So, and that's, I don't recommend that to anybody unless you've been doing this for years and you're the next Winston Shrout.
Your pay grade,
Yeah.
you said the secure party could be done in one day.
Yeah.
You mean choosing to be it, or the documents that you have?
No, the documents. A commercial security agreement, property list, and a UCC-1. Boom. Done. Now, once we get into the instruments, which I may have had on here. Yeah, we do have the birth certificate bond, the indemnity bond, the set-off bond. You'll see that he registers the instruments and assigns the instruments with UCC-1s and UCC-3s as well. You guys, There is no limitation on the UCC ones you can file. I've seen people try to add everything to one UCC. I'm like, why didn't you just file a separate one? Like, if I'm just registering a bond, I just do a UCC one. I can have the same secured party and the same debtor as my other UCC one. I'm just listing in the collateral a series of bonds. I'm basically claiming that private bonds for set-off or private bonds, private indemnity and discharge bonds, this unique identifier number through this unique identifier number are collateral on that UCC1. And then if I do any assignments, meaning I'm issuing the bond to, let's say, a court, I would then do a UCC3 assignment of that one bond number. So now I've recorded my interest in the instrument, and I've recorded the assignment of the instrument. When you guys start playing with instruments, you want to make sure, especially if you're dealing with these guys in the public, that you're registering your interest so that you could show I'm the originator of this commercial energy. So that's why we register it on the UCC1 and we assign it with the UCC3. And an assignment is basically saying, hey, I'm taking this instrument, let's say it's a bonded promissory note. So I can register one bonded promissory note on a UCC1. Put the amount on it and everything. Say, I'm registering this $5 million promissory note, private trust secured party, public trust debtor, because it's for and on behalf of the public trust, right? And then I assign this bonded promissory note to the bank. So I'm going to record the assignment, and I'm going to record the assignment to two parties. What are the two parties I'm assigning interest in the note to? Anyone? Anyone? Bueller? The CFO and the bank. You see why I would do that? Well, let me take that back. If I sent the bonded promissory note to the bank under the CFO's care, right? There's two parties I'm going to hold liable on that assignment. The bank itself and the CFO. Did you know you can assign the interest in one piece of collateral to multiple people? Yeah. I can assign the interest in that instrument to 10, 20 people. There's no limitation on how many people I can assign that interest to. And you can actually do it on one UCC3. There's an additional page called a UCC3AP, which is for additional parties, which goes with page 1 of the UCC3. So you now assign it, and an assignment is you just fill out the UCC3 as an assignment. You mark the collateral as assigned collateral, and you write the specific bonded promissory note number in there and the amount of it. That's clearly identifying the collateral. So now you clearly have an interest. And if you're issuing, let's say, on behalf of an account, you can now register your interest in that account. Because now you have a security interest in that account which you're discharging. Let's say the account is a court case. I can register my interest in the case.
Why would I?
Claiming it. That's mine. It's my collateral. If I put up a $50 million note on this court case, I've got a $50 million interest in that court case. What's it mean? If I file a UCC1 and I list the case as the collateral, what's that entitle me to? I get the proceeds. I've got a claim. Just like if I have a UCC1 on a house and they want to sell it, who's got to get paid? I do. So if I have a UCC1 filed on a court case and it brings in money, who's got to get paid? I do.
Is the case open or closed?
Is
Court case, for example.
is
How long
the,
does it stay open, or does it ever close?
it's just like any other account.
Okay.
If it closes, it's for set-offs and adjustments. So it's not really ever closed. Any other questions?
Do you have to put a number when somebody files UCC1 on your house?
Do I have a what?
If they don't put any dollar amount on the UCC1, can they amend into it?
Can they amend it?
Yeah.
Yeah. Yeah, you can amend the collateral. You can you could change the collateral, or you can amend the collateral. You can add to the collateral. When you look at a UCC3 amendment, okay, so you're not doing an assignment, you're doing an actually.
Would you do
I think I know one. Yeah, UCC3 is an amendment. Yeah, you would do a UCC3.
Now we're back, Morris. Now I wanted to run that because what we're discussing here is the setting up of a trust and the actual components inside a trust and what you can do once you learn this stuff. This is not something that you learn overnight. You want to get the thing actually set up first, and you want to clearly define the terminology in the documents that you have so that you will know what you are doing and how to take it to the next level. And just like the guy was talking about bonding court cases and stuff. And for the most part, most of us people who are operating in the private or public, we don't know anything about that. I mean, that's a whole different level. But once you get the correct structure and you clearly understand, you take your time and you understand what it is that you have put in there, just like the information that I brought to you tonight about the declaration of trust, the duties of the trustee, what they have the authority to do, what they have what their duties are, what their job is, what they can do. When you create this on contract, when you put this on documentation and you add it to a trust, okay, remember you're adding this to a grantor, the one who created the trust, the trustees, the people who are administrating the trust, on behalf of what? The beneficiaries. So this is a barrier of protection for you with the things you're trying to do. There are people who they're going out and they, well, I own real estate. I just fixed up this house and now I'm renting it out, and now I'm going to see another house, then I'm going to take the money from this house and buy and get another house around the corner. And then I'm going to go get another one and another one and another one. I had talked to a man one time. This man told me he had over 23 properties, and he ain't making no money off of none of them. Well, when I went home and I checked, I looked at the current real estate cycle, and I said, well, you sure ain't going to make none because the real estate cycle is down. You got to catch it up on the upswing. So if you can hold on to these properties and you can make sure that the taxes is paid and all that stuff, if you haven't already gotten rid of the taxes and stuff on the property, he may have fared much, much better if he had this assigned to a trust. You understand what I'm saying? Whatever it is that you have, you want to create and put it in a trust. Now, we do have organizations that are functioning under trust, and what they're doing is they are getting peoples and adding peoples as members to their organizations. They are getting the members to turn over their assets, their houses, their cars, and furniture, and all of this stuff to the trust. And the members of the trust, they are we don't know whether they're beneficiaries or not. We don't know what's going on, but we know that these people are turning their assets over to a trust. But what I'm trying to get the listeners to do here is to learn this stuff, create your own trust, put your assets in your own trust, have your trustees administer your trust on behalf of your beneficiaries, opposed to allowing someone else to tell you to hand over your assets to them and they'll hold it in the trust and now it's protected. And you can have the use of it, but it's held by trust. And what is that? It is on contract. But let's go back over here to the Declaration of Trust. And we was talking about the Board of Trustees. Okay, this information is included in your trust. This is part of your trust, the declaration of trust. As a board of trustees for the purpose of holding and administrating company assets for the benefit of certificate holders, all members of the board of trustees shall serve without bonds. Okay, so your trustees do not have to be bonded. Okay, discretionary powers. Now, this is a part of your trust also. This is listed on the Declaration of Trust. The parties herein agree that the Board of Trustees shall have absolute and sole discretionary power over this organization, its assets, and earnings therefrom. The Board shall have authority to A, determine what shall constitute principal and earnings, how such assets shall be allocated, and shall have absolute authority to determine if and when distribution of principals or earnings will be made to certificate holders. Acceptance by trustees. This is next. The first trustee and all subsequent trustees and successor trustees, by accepting the appointment as trustee for this organization, causes all present and future trustees to agree to the following. They accept the initial gift or conveyance of property on behalf of the organization and acknowledge the delivery of all property specified on Schedule A. Now, remember I was telling you earlier about Schedule A, where you have listed all the assets. And as we just learned from the broadcast, the little plug that we just what we can do with the Schedule A and add on and amend and all of that stuff. Okay. They agree to conduct the organization's affairs in good faith and conformity with terms and conditions set forth in this contract and its inherent trust provisions. They accept the initial gift of conveyance of property on behalf of the organization, once again, and acknowledge the delivery of all property specified on Schedule A. Okay, let's clearly understand that. Excuse me. They agree to exercise their best judgment and discretion to conserve and improve the property of the trust estate in accordance with decisions of the Board of Trustees as set forth in the organization's minutes. Okay, now, when you are setting up your trust, we know there's a grantor. We know there's trustees. We know there's a Schedule A. But when we hold these meetings, we need to create the documents of the minutes of the meeting. Now, this is the same. I know quite a few of you have probably already heard this before, that when you have a business meeting and you have, we're going to say you have a corporation set up, somebody takes the minutes of the meeting and stuff. Well, this has to be recorded. The date, who's present, the time of the meeting, exactly how many minutes the meeting lasts, and this stuff is going to have to be put on a document. And this is what the trustees and the organization is doing, that they will provide a record of, along with the Declaration of Trust, along with the Schedule A and all of this stuff. Okay? All right. They agree to exercise their best judgment and discretion to convey and improve the property of the trust estate in accordance with the decision of the Board of Trustees as set forth in the organization's minutes. Okay, so we're taking the minutes of the meeting where we're showing anybody in the public that this is not just some fly-by-night situation that's going out. We have a real trust. They're real trustees. We are following the best possible information that we have according to law to establish this thing correctly. Here is proof on paper. It's a part of your document. Okay? All right. They agree upon final liquidation of the trust. Now, if you're going to liquidate a trust estate, to distribute the assets to existing certificate holders as their contingent rights may appear. Okay, this is already contained in the trust. Administrative provisions. Trustees and their successors may hold administrative offices within the organizations and may singularly or collectively exercise authority granted by the Board of Trustees in the management of company affairs. They are herein authorized to exclusively manage, administer, and control the trust estate without consent of certificate holders. The following specific terms and conditions apply. Now, here we go. This is under the administrative provisions. The Board of Trustees shall be at least one in number and may be increased as deemed necessary in the manner set forth above. The trustee may resign or be removed from the board with or without cause by a resolution of the Board of Trustees determined by a majority vote or by a mandate of a court-competent jurisdiction. In the event of death, removal from the board, or resignation of a trustee, the vacant position shall be filled by a successor trustee. If pre-appointed, or the remaining Board of Trustees may appoint a successor by a unanimous vote, should the entire Board of Trustees become vacant upon proper application by a qualified party, a court shall appoint one trustee who, after accepting the appointment, shall in turn appoint a second trustee, and they may jointly appoint others as provided in the manner set forth above. Okay, so now we have a situation where, in a situation where an existing trust, the trust hasn't expired, we've got beneficiaries at stake, we still got the grantor, the trust still is in exist, the record is there, so they are bound by the stipulations of the trust. You understand why it's so important? See, this thing, when you set this up, this thing structured in a way on contract, because see, everything in America operates on a continuous use contract. Now we're going to get down later on a later date. We're going to be dealing with an administrative process where you are actually functioning, not on a regular administrative process that a lot of which we do in dealing with debt collectors and foreclosure and stuff like this. We use an administrative process there, but we're going to show you how an administrative process works when you are in a court situation, when somebody is challenging, trying to challenge the trust. If you're wise enough, you've created the trust, you know how it functions, everything is there, everything is in order, and all this good stuff, so you don't have to worry about that. Okay. Let's go to the next thing. Under administrative provision, the signing and acknowledging of this contract by any trustee or trustees shall constitute trustee collective acceptance of this contract in its trust provisions and trustees' acknowledgement that this organization's property and assets are vested in fee simple in the trust estate without any further act or conveyance by the Board of Trustees. Trustees, as discretionary fiduciaries, shall hold legal and equitable title to all assets. The Board of Trustees may provide the meetings at the stated intervals without notice, and special meetings may be called at any time by one or more trustees upon 3 days written notice. At any regular or special meetings, a majority of trustees shall constitute a quorum for conducting business, provided affirmative action may only be had upon a majority vote of trustees, whether present or absent, except that in special meetings called for the special purpose, the majority present may affirmatively act in emergency matters. A telephone or fax vote shall be a valid vote. Any resolution of the Board of Trustees shall be deemed within the Board's power, so long as the resolution is not inconsistent with this organization's document and any amendment thereto. Trustees shall be controlled by this document as amended and further resolutions of the Board of Trustees. All meetings and resolutions shall be recorded in the company minutes book. See what I was talking about the minutes of the meeting? Trustees shall keep proper records and accounts as the Board of Trustees deem necessary for the proper management of the trust estate. So now, the trust declares that an estate exists. You have your estate there. It has to be treated as an estate because it is recorded as an estate. Okay? All right. Trustees shall not be required to individually assume liability for loss of company assets while acting in good faith on behalf of the organization or for any act or omission of any other trustees, agents, or employees. They shall, however, be liable for their own breach of good faith if such breach is established in court of competent jurisdiction. If a trustee shall, for any reason, suffer a personal loss while providing good faith service to the trust, the trustee shall be reimbursed for such loss from the trust estate. The Board of Trustees, at the expiration of the term as set forth herein, shall wind up company affairs and terminate the company's operations, making final distribution as provided. If the organization was recorded publicly, trustees shall file with the recorder a notice of termination, and the trustees thereupon shall automatically be discharged, provided final administration and distribution was made in accordance with the terms and conditions of this agreement. Otherwise, a court of equity may be invoked to review and correct any tort or error. Okay, I want to stop right there. Now, when you do a trust, you want to have that trust constructed to keep it away from any type of probate. Because it's actually designed and structured that way if you create it that way. This is why it's so important for you to have a declaration of trust. And you can amend these documents. You want to make sure that as time go on, if you, as the grantor, foresee some things, you can bring it and amend the thing to get it with functions much more streamlined and much more easy. When there are no longer trustees and beneficiaries, the manager will have the right to dissolve the trust by following the procedure in J. All right, now let's look at J again. The Board of Trustees, at the expiration of the term as set forth herein, shall wind up the company affairs and terminate the company operations, making final distribution as provided. Okay, which means that if you get in a position where you have trustees and a trustee pass and you're still living, you can appoint another trustee, or you can actually collapse the trust. You can start over. There are people that's building bridges, highways, buildings, and all kind of stuff that have trusts. They're setting up LLCs and building the bridges, and when it's done, they collapse that trust that was set up for that operation. So once you learn this stuff, you can live with that particular protective umbrella. It all involves learning this stuff. You understand? Okay. I'm going to continue, but I'm going to take a little quick commercial break, and we'll be right back. So y'all hold on.
Now just think for a moment. Most of your life, you've been trying to be free in America, but you just haven't gotten there. America is made up of men and women. Let's correct your status in commerce. Call me, Tarhaka Black, 904-303-9061 before 7 p.m. Eastern Standard Time. That's 904-303-9061 before 7 p.m. Eastern Standard Time. Go to www.newdebtelimination.com. That's www.newdebtelimination.com. Let's live life with some real power. Let's start changing your life. Let's take a look at the real stuff. Get with Tarhaka Black, www.newdebtelimination.com. Peace.
Okay, we're back. All right, let's go on down to the next one. And we just dealt with FGHIJK L. We're down here on L. Any affidavit for public notice, declarations, and honorable clarifications not limited to any corporeal or incorporeal hereditaments concerning any conveyance, including in the security agreement and authenticated foreign documents, is under the Hague Convention, 5th of October, 1961. Okay. Now, that comes under the heading, everything that I just brought you comes under the heading in your declaration of trust under what's referred to as the administrative provisions. But now we're going to deal with trustee powers. Trustee shall have general common law powers over the company and the trust estate herein, and may do anything any citizen may lawfully do in any state or country, specifically but not by way of limitation. They shall have all rights, authority, and powers as follows: to compromise or abandon any claims arising out of, in favor of, against the company, its trust estate, and trustees' good faith decision in that regard shall be binding and conclusive on all parties. To manage, invest, and reinvest the trust estate or any part thereof in any kind of property or venture which men of prudence, discretion, and intelligence consider for their own account, without being restricted to investments which are ordinarily permitted by law or customarily used for trust funds, and without restrictions as to the duration of this organization. Specifically included, but not by way of limitations, are real estate collectibles, gems, artwork, precious metals, corporate obligations of every kind, preferred and common stock, commodities, mutual funds, and trust funds, to open, maintain, and close bank and thrift accounts of every kind, and to conduct all monetary affairs of this trust, to sell at public or private sale for cash credit or cash or credit, and upon such terms and conditions as trustees may deem proper, to sell, grant, convey, mortgage, options, rent, lease, or pledge all trust estate assets, real, personal, or mixed, in such manners deemed appropriate and moderate to the general welfare of the trust, to borrow, own, or encumber the trust estate without restriction, and to make loans with or without security. All borrowed funds shall immediately become a part of the trust estate, to allocate capital gains or the dividends of trust principal as may be deemed appropriate or advantageous to the trust estate. Now, these are the powers that the trustee wills. So when you are setting up your estate, you want to make sure that the individuals that you are dealing with that are going to be trustees of the estate, all y'all going to have to be on the same page. I know that people would do anything to gain a benefit or avoid a loss. And when you're dealing with people, you want to always show people, number one, what they can profit, when they can profit, where they can profit, why they can profit, who says they can profit, where they can profit. When you have to answer these in the minds of people to benefits to be gained or loss to be avoided. And the same technique applies to when you're dealing with your trustees, the grantors, the beneficiaries, and anybody else. Okay. Now, before we get down into more of this, I'm going to go over here to the other documents that I have, and we're going to come back with more of the powers of the trustees. Okay. So just hold on one second. Let's get down here and finish this, because we started this at the top of the broadcast. I'm doing my best to try to get as much in as I possibly can. We don't have any storm zones, so this should be coming across and where you guys can hear me. And I'm not certain how the broadcast is going to come out, but I'm going to see when the show is over to make sure that everything is right. And if not, then I make all the necessary adjustments to make sure that the stuff comes out so that you can get this information and understand this information when you are setting up your trust. Okay? Now, we was talking about why use is better than ownership. Okay? In other words, if you own a home, have a bad automobile accident, where you destroy another's property, the car insurance may not cover the damage. Usually, the claim may require your home to be sold to pay off the debt. If you do not own the home, though it cannot be forfeited, there is no asset for the plaintiff to claim. You say this is twisted. This makes no one responsible. This thought is how most political protected politicians configure their assets. They put them into what is known as a blind trust. These high officials in government cannot be sued for anything substantial. They have little in their name, perhaps a personal checking account, an old car, or something like that. Since we cannot infuse morals and ethics into the society, we can only see to it that people are protected from frivolous lawsuits over which they have no control. For example, if you lose your job, your home can be lost, and then the IRS can hound you for years for back taxes. This is not true when you place your home in an irrevocable trust. It is removed from you, providing there are more than 18 months between the event and when you put the home into trust. The only time the trust, which holds the property, could be involved in a claim is if the trust acting as trust causes the damage. For example, the Board of Trustees hold a function at a person's home. The trustees sign an agreement. The facility is to be used for 5 hours. During that time, the party gets rowdy and the furniture and windows are damaged. Now the trust is clearly responsible for the harm and is responsible for paying the facility owners. What about marriage? Assets in a trust before the marriage remain in trust, as they belong to neither the groom nor the bride, but to the trustees held for named beneficiaries. Assets gained after a marriage can be community property unless the trust buys them and keeps them for the children of the newly married couple. The couple can also put new assets in the trust for the children. We have one circumstance where a person had all his assets in trust, and he wanted to marry a fine woman. He explained to her that he owned nothing, as all his assets were in trust. She fled the relationship. Okay, one could say that after him for his money, that she was after him for his money, or maybe he did not offer initially to fund a trust for her. Gullible but rich. There's also the not so uncommon event where assets are in trust, and the gullible, not so beautiful beneficiary marries the dazzling princely rogue. If trustees are doing their job, the cunning husband wastes oodles of time and money going to court trying to get the well-protected wife's asset. He will eventually discover that she does not own them, and the trustees do not care about his plight. As a reminder, please do not confuse the word trust with statutory living trust. In a living trust, property remains in the name of the original owner and is not removed into the names of the trustees. Therefore, a living trust offers no asset protection and only limited probate protection. Limited probate protection. Remember, I was telling you about that word probate. The chapter exposes you to potentially huge economic peace of mind. Legal and tax advantages of having this use of property is an irrevocable trust without the headaches and legal exposure of ownership. Now, for a deeper understanding, it's time to share with you the history and evolution of trust. Now, this is deep, so I'm gonna hold off on that. We will be coming back with part 3 of this particular information, and so that you can understand more about setting up your trust. And this is all in conjunction with being a secured party. Being a secured party, that's the easy part. You simply act like one first. You got it in your mind. You watch your behavior, your attitude. You're not trying to flex on anybody. I mean, you got you understanding who you are. You know who you are, and you got documentation to prove who you are. You just happen to be protected by trust, opposed to being out there some sole proprietor. You're just purchasing real estate and you're making money. So you think you're making money, but you're getting debt notes and you're unprotected, you're making repairs, something happened, all this stuff, then you're responsible and liable and all of this business. So setting up the trust and learning how to act as a creditor in commerce. There's a difference between a creditor and a debtor. So because when you get stuff in the mail, it's coming to you from a creditor. They're listed as creditors. The light bill, the mortgage company, all these people are listed as creditors, and you're listed as the debtor. So what you want to do is to learn how to be a creditor, and you want to do that in the private. Now, if you have full knowledge about the public, and most of us by now should have full knowledge of how to operate in the public, because you've been doing it all your life. But now we want to learn what's available to us and how do we function in the private. And in my opinion, I think that there should be time set aside by you in your life so that you can study this stuff and look around and watch how the system is operating in the public. And then when you actually have learned enough, or you think you know enough, you got to get out there and you got to try it, man. You got to put your foot out there. You studying for 10 years and then starting to do something. No. It ain't gonna take all of that. You get this stuff. And the reason I'm saying this is because I've talked to people, and they have told me, well, I have my trust set up. Okay, I have my declaration of trust. I have my indentures. I've done my UCC. And then the next question is, well, what to do next? Well, wait a minute. Hold on. If you have that, and you have studied it, and you have defined it, that shouldn't be hard for you to figure out. I mean, I'm just saying, man. This document that we're dealing with alone, just this one alone, the Declaration of Trust, it's describing to you all of the components of who everybody is, what they can do and what they can't do, and so you ready to go now? Okay, if you're gonna start getting into real estate, or you're gonna start getting into silver and gold, or if you're gonna be playing the stock market, or if you're gonna be dealing with rental properties, or if you're gonna be buying houses, fixing them up, selling them, you're gonna open up a restaurant, if you're going to open up 2 restaurants, if you're going to create a product and start marketing it on stuff, you need to be protected. So let us study the protection and get that down to a science. Let us create what we're going to do, and let us become functional inside the trust. Okay, let us continue on the same Declaration of Trust, because this thing here, it is very, very detailed. And what it does is it clearly describes everything that everybody can do, who they are, everything about it. Very, very detailed. To register company property in the name of the company, a fictitious trade name of the company, a trustee, a nominee, so long as company ownership of such property can be clearly demonstrated. Let's go to I. To make distribution in cash or in kind to the assigned value to such property according to trustees' best judgment. J. To accept additions to the trust estate by deed, will, assignment, exchange, gift, grant, insurance, proceeds, or any other method deemed acceptable of trustees. Trustees are further authorized to honor any buy-sell agreements extant as to any property or interest held in trust, to elect and remunerate officers from the board or elsewhere as deemed appropriate or expedient, to hire, remunerate employees, agents, or contractors, to incur and pay the ordinary and necessary expenses of administration, including but not limited to legal fees, accountant fees, trustee fees, brokerage fees, consulting fees, and the like, and to allocate all of the expenses and receipts between principals and incomes as trustees should deem proper. L, to give proxies to deposit securities with and transfer titles to committees representing securities holders and to parties in voting trust organizations and other transactions involving the common interest of security holders. Okay, now if we stop right there, you have already made provisions in your declaration of trust when you start dealing with securities, discharging of debt, securities, bonds, and of course, we have been. I've been asked by many people about, well, how does the birth certificate and Social Security play into that? Those are instruments that has bonds behind them, and so here is a provision that you have in your contract beforehand that gives the trustees the ability to use that. Okay, you see how this thing is structured? See, everything in America operates on contracts. Everything. You can't, all in the public, all in the private. So if you understand that, you set, and this is your contract, by the way. Now this doesn't belong to anybody else. This belongs to you. Okay. And so you want to make sure that your contract gives you all the working room you need to do what you got to do. Let's go down to M. To open margin accounts with securities, firms, and commodities, traders, and to buy, write, or trade in options, commodities, and to make short sales, trustees shall be empowered to hold securities in their own names, the name of the nominee, and street name are unregistered in such conditions that ownership will pass. Trustees shall incur no liability to the company for any loss. Further, any securities firm or commodities trader may rely on this document and the trust provisions herein in respect of a trustee's authority without making further inquiries. The trustee are expressly authorized to hold, manage, and operate any company property or business or enterprise. The property and losses, if any thereof, shall be chargeable, respectively, to the trust estate. Trustees are authorized to pay all taxes out of the trust estate and have complete discretion, power, and authority to make any decisions or election that would effectively minimize such taxes if any taxes are eligible to be levied. Trustees may expressly delegate one or more of their powers to any such person or persons as may be deemed expedient for the management of company affairs, and may revoke such delegation at any time by written notice delivered to such persons. Trustees, by majority vote, may change the domicile of the company with or without cause if they deem such change will protect or benefit its trust estate. Trustees, by a unanimous vote, may make amendments to this contract and declaration and take such other consequential actions as they deem necessary or appropriate to protect the integrity of the organization and to ensure the organization will continue to function and be administered in the best interest of certificate holders in the manner intended. And last but not least, the powers of the trustees. Trustees, by majority vote, may at any time and at their sole discretion wind up company affairs, terminate this organization, and make distributions of the trust estate to certificate holders as provided herein. Okay. All right. Now we're gonna stop there on this document because it goes on, and I like it because this thing is very, very detailed, and we're gonna get through it. And to keep in mind now, this is just the declaration of the trust, because this document here describes the whole motorist apprendi of who's who, what's what, who have power to do what, and it protects who. It protects the beneficiary and the creator, what we're calling the grantor. See, opposed to you going out and fighting and battling, and I'm trying to save my home. Okay, but let's be wise. Let's look at and when you do save your home, let's take it and put it somewhere where it will be protected. Let's take your assets and protect them. Let's protect your assets, opposed to just having things out there and they are unprotected. Okay. All right. Now, at this point, we have an hour and 20 minutes left. I want to open up the phone lines. The number to call in is area code 310-982-4184. 310-982-4184. Press 1 on your phone if you got a question, and I'll do my best to answer the question that you have in regards to what we are dealing with. Okay. I'm going to take a little quick break, and when I come back, I'll be ready to answer the question, then we'll go back down into the lesson. So y'all hold on a second.
You don't have to lose your home due to foreclosure. You don't have to worry about child support. You don't have to be in credit card debt. Have no fear. Tarhaka Armana El Bay is here at newdebtelimination.com. Got student loans, child support, mortgages? Contact someone who's got the experience and the knowledge to get you back under God's law. That's Tarhaka Armana El Bay. He's been there, he's done that, and he can prove it. Just give him a call at 904-303-9061. That number again is 904-303-9061. And log on to newdebtelimination.com. That's newdebtelimination.com and get yourself free.
Blog Talk Radio.
He is the last of his kind. All that remains of a once powerful nation. Some think he is a myth. Some believe he is the chosen one, who will bring balance to a world at war. And some will stop at nothing to destroy him.
Welcome, Moorish to Moorish Talk Live 100. I'm your host, Tarhaka Armana El Bay, and tonight we'll be dealing with part 2 of setting up trust using the private. Now, I have to say that I apologize for part 1. We had some tornadoes blowing through here that Sunday, and I guess most of you all already know the devastation of what happened, but I did let everybody know up front in the event, and it was looking good, but all of a sudden, boom, we got hit. So we lost a lot of very important information in part 1, so I'm going to do my best to bring that back to table in part 2. and then we'll be coming back, and as we go along, we'll be doing bringing other information involving your trust and operating in the private. Okay, I'm going to go to the commercials, and when we come back, we'll be ready to go in. Okay, so y'all just hold on a moment, and we'll be ready to go.
Still, one of the biggest problems facing people in this country today is debt. The election of a new president doesn't mean your debt will go away. For student loan, child support, mortgage, foreclosure, credit card debt, etc., contact me, Tarhaka Black, 904-30.
All right, we're back. All right, now the next area that we're dealing with in the same declaration is the right to distribution. Now, we just came off of the trustees' power, what they have the right to do according to that contract, and now we're going to look at the distribution. Trustees have discretionary powers to make distributions from this organization without regard to equality of certificate holders, except for final liquidation, notwithstanding a right to any distribution from this organization shall be evidenced by the holding of one or more certificates, and the following provisions respecting such certificates shall remain in full force. Now we're gonna get to the certificates that we're mentioning here, because I know you hear me mentioning about certificates, and we're gonna get it there. Shall remain in full force and carefully observed by trustee certificate holders and interested third parties at all times. A trustee shall be authorized to issue 100 certificate units, hereafter called TUCs, of certificates, representing 100% of the rights to distribution for the organization's trust estate. Trustees shall not issue TCUs in excess of that number. The TCUs shall have no par value, and trustees shall not place any normal value on TCUs at any time. TCUs are non-accessible, non-taxable, non-negotiable, and limited in transferability. The lawful processor shall be construed the true and lawful owner thereof. Creator herein may own TCUs. No person having or controlling a majority vote on the board of trustees, however, shall have or possess any rights to distribution from the trust estate. B, trustees are authorized to receive property into the trust estate in exchange for negotiated numbers of TCUs. The property exchanging the property shall be deemed, the party exchanging the property shall be deemed to be an exchanger. All owners of the TCUs shall be identified as registry of trust certificates units, kept in the company minutes book. Ownership of TCUs shall not entitle the holder to any legal or equitable title in the company or the trust estate, nor to any undivided interest therein or management thereof. C, TCUs shall be immune from seizure by any creditor of lawful owner. Death, insolvency, or bankruptcy of any TCU holder, or the transfer of this TCUs by gift, exchange, or sale shall not operate as dissolution of this organization or its operation of business, nor shall such events entitle his creators, heirs, or legal representatives to deem any partition or division of the trust estate or any special accounting. Death of TCU holders shall terminate his or her rights under the TCU, and said rights may not therefore pass by probate or operation of law of any heir or legatee, but shall revert to the Board of Trustees to be reissued as determined by an action of the Board. E, TCUs may be surrendered to or transferred back to the organization subject to the approval of the Board of Trustees, but may not otherwise be pledged to sign, hypothecated, or transferred by a TCU holder without the consent of a majority interest of all other current TCU holders. Should a TCU holder transfer or surrender his TCUs to the organization, the Board of Trustees may at his sole discretion assign, convey, or exchange said TCUs to any other persons or entities upon approval of the board. If any TCU holder contests in any court of law the validity of this organization or any provisions herein, or the authority of trustees, that the TCU holder's certificates shall revert back to the Board of Trustees and may be reissued to other parties at the discretion of the board. Okay? Now, that's just another part of your declaration of trust. As you can see, this declarations give the trustees an enormous amount of power and stuff, but we're dealing with what? We're dealing with trust. So when you are establishing your trust, you want to have somebody that's on the same page. I mean, if you know this stuff, I mean, I have access to this stuff. It's all there for me to look at. I can orchestrate this stuff from one hand to the other. So therefore, if I'm going to deal with this, I want to have somebody that has full knowledge of this information, even if I just gave them their role and what they are expected to do. We still had to be on the same page because we're dealing with a trust and beneficiaries, and what we're doing is we're putting together, we're managing assets, and of course everybody's going to benefit from this. However, it's for the main benefit of the trustees of the trust. Negotiation and exchange, which is next. The trustee is herein authorized to bargain, exchange, trade, or sell certificates to a willing exchanger upon board approval at the initial Board of Trustees meeting or at any time thereafter. Notice to third parties. Notice is hereby given to all persons, companies, or corporations extending credit to contracting with or having claims against this organization or its trustees that they must look only to the funds and property of the organization for payment or for settlement of their damages, accounts receivable, or claims. Trustees, officers, or agents of this organization are not personally liable for the organization's obligations. Now, if you can understand that, that is amazing. We have this organization set up. We have a tremendous amount of assets in the organization, but the trustees as manage everything is not liable. Now, this is on contract, man. This is amazing. Copies as originals. A copy of this original document herein the seal or signature of a trustee or a copy certified by a notary public as a correct copy shall be relied upon as an original document and shall have the full force and effect of the original document in every respect. Purpose and intent of this agreement. This contract with trust provisions is intended to create a common law contractual company, also known as an unincorporated business organization, for receiving, conveying, or holding property in free simple, and for providing prudent management of such property, and for conducting any legitimate business through appointed trustees for the benefit of certificate holders. Trustees shall hold both legal and equitable title to the trust estate and shall act solely within the powers as provided herein and within their common law rights and immunities. The administration of this organization shall be amenable to judicial regulations and under the protection of the court. If any provision herein is unenforceable, the remaining provisions shall nevertheless be carried into effect. Nothing herein contained shall be construed as intent to evade or contravene any law, nor to delegate to trustees any special powers belonging exclusively to a statutory company, franchise, or incorporation. Okay? Let's go to the next one. It's called the Common Law Organization. Creator expressly declares this to be an organization founded upon the freedoms and rights inherent in the common law of the Republic of the United States of America, and all references herein in the United States shall be construed to refer to the constitutional United States of America in its original context and set forth in the Constitution of the United States, the original Bill of Rights, and the state constitution for the several sovereign states comprised in the Union of the United States of America. This organization then is created under the common law of contracts protected by Article 1, Section 10, Parallel 1 of the Constitution of the United States. It is therefore not created under the statute of any U.S. state and does not depend upon any statute for its existence. It is not a partnership, a corporation, or statutory trust, but a separate legal entity having its own common law identity. Next is legal domicile. This organization shall be domiciled in the state where it conducts its principal business, notwithstanding, Creator herein provides that upon the majority vote of the Board of Trustees, the organization may be moved and administered in any state or territory of the United States of America and in any English common law foreign jurisdiction. This original document and all company business shall be kept private, protected by Privacy Act of 1974, 5 U.S.C. 552A. The Fourth and Fifth Amendments of the Constitution of the United States and the common law privacy rights available in the United States of America and every other applicable jurisdiction. Term of years. This organization, unless terminated earlier and provided herein, shall continue for a term of 25 years. The life of the company may, however, be extended for an additional 25 years, subject to a unanimous affirmative vote of the Board of Trustees at least 90 days prior to each termination date. And at dissolution, the trust estate shall be distributed on a pro rata basis to the then existing certificate holders. The company name is next. This organization shall be named as shown on page 1 of this contract and declaration. This shall be deemed the company name. Company business shall be conducted under this name and under one or more fictitious trade names or any name of the trustee or nominee determined at the sole discretion of the Board of Trustees. In witness whereof is next. Creator and exchanger execute contract and declaration in recognition of delivery and acceptance of the property name herein and in recognition of the powers and duties imparted to trustee to his organization. They assent to all terms and conditions set forth herein and declare that the effective date of this organizational documents is infra. And then we go down into the acknowledgement. In compliance with Title 28 U.S.C. 17461 and executed without the United States, we affirm under the penalties of perjury under the laws of the de jure United States of America that the foregoing is true, correct, and complete to the best of my belief and informed knowledge, and further the deponent saith not. I now affix my signature and official seal to the above document with explicit reservation of all our unalienable rights without prejudice to any of these rights in compliance with UCC 1-308. The assignment is entered into and executed willingly, knowingly, and voluntarily by each party in good faith, and shall endeavor to execute the promises and terms and conditions herein with diligence and in the best interest of other party on this particular date, A.D. Executed at the following address. Okay, and you can put in your address here. And the creator on one side, the exchanger on the other. Witness, we are unassigned witnesses hereby stand and attest that the four signed this document on date listed supra of their own free will as witnesses by our signatures below. Okay, and then you got your witness's signature and your second witness's signature, and you can put other witnesses there. It depends on how you want to set that up at the close. And this is your declaration of trust. You can go ahead and list your assets on your on your Schedule A document. List all assets, belongings to that could and on this thing down here on your Schedule A. That's what I'm trying to say. Include legal description, reservation, number, make, model, VIN numbers, et cetera, when you're doing the Schedule A. Next comes the minutes of the meeting. Okay. And before we get into that, we're going to I'll go back because I got to make some announcements for those of you who are new or just tuning into the broadcast. On the last Sunday this month, and if I'm not mistaken, I don't know now. Y'all correct me on this, but I'm thinking I think it is the Super Bowl is supposed to happen on the 29th of this month. I think. I don't know, but we'll be on the air. You know, I mean, y'all might be looking at the Super Bowl, but me and Brother Walter Williams going to be on there, but you don't have to worry about it if you miss it, the initial live broadcast, because we will be converting the broadcast into putting it over there on YouTube so you can go back, and, of course, you know, I put it in all the other places so that the people can actually won't be missing out on what was discussed in the event that you're going to be watching the Super Bowl. But me personally, I won't be doing that. I'll be on there because I don't deal with none of that. Anyway, and I mean, don't get me wrong, man. When I was in school, I played football. I found a old photograph of him in the actual yearbook, Reebok Senior High yearbook. I think it was 1971, 1972 when they had the offensive players there, and I'm number 15 right there. So, and I'm looking at myself. I said, "Boy, I thought I was a hot potato back then in the day, but it's over now." I played games when I was a young man, but now it's time to get on with bigger and better things, and this is important. And I would like to see my people put games aside and start dealing with the things that men do. Okay, the wealthy and the powerful. We want freedom, and this is an excellent way to get it. You want to be a secure party, but it is not just the documentation. Let's get that part straight first. It's not just the documentation. The documents are important, but we want to clearly understand in our mind and know for a fact that we are free people. And if that is the case, then you want to act like that. And the documents simply verify your position. Now let's deal with the minutes of the meeting. The initial trustee meetings of such and such a trust. The date is there. The first trustee is listed of the aforementioned trust was present and constituted a quorum of the board. Trustee called the meeting to order and affirmed that on blank date on April 31st, 2017, it accepted the appointment of first trustee of the trust created thereby, and announced that the trust became fully operational as a separate legal entity on that date. A temporary secretary, as undersigned below, was appointed to record the minutes. Trustee approved the initial exchange of the attached addendum to initial meeting and authorized the issue of agreed number certificates to the exchanger. Trustee then appointed so-and-so, another trustee, and the party being present accepted the appointment and affixed their signature below. Trustee stated that the trust was in immediate need of a person or persons who could serve as managing directors. After discussion and upon motion duly made, second, and carried, it was resolved that the following persons herein named as the officers of the trust to serve without bond and until replaced by resolution of the Board of Trustees in the capacity as identified below. And you can have the names here on one side, the name on for second trustee on the other. It is decided that the managing directors, A, will be authorized to conduct day-to-day routine business without need of board action, to hold trust business meetings, and to appoint assistants to hire personnel as deemed necessary. C, shall be authorized to open one or more checking or savings account at a financial institution of manager's choice and maintain such accounts at the manager's discretion. However, all questions related to legal termination, tax planning, exchanges, or purchases of real or personal property The issuance of trust certificates, units, and other such important matters shall require approval of the board. The secretary shall keep minutes of all future business meetings and board trustee meetings. Act in the best interest of all trust certificates holders through prudent record keeping of certificates, transfer, and other business respecting the holders and this trust. Trustee and officers shall be independent contractors. Execute a written contract with the trust setting forth any specific duties, responsibilities, general working relationship, services to be rendered, and compensation. Execute each contract by Board of Trustees or Managing Directors or Secretary and recorded in the minute book. All trustees, officers, and agents of this trust shall respect, keep, and preserve the privacy of the trust, business dealing records, and the like, not divulge private information to third parties or government agencies or courts without express consent of the Board of Trustees. There being no more business before the board, the meeting was adjourned. The place of the meeting, the trustee's signature, appointed trustee's signature, temporary secretary's signature, and a temporary secretary's name. Temporary secretary's signature and a temporary secretary's name printed. Okay, this is so. What this is telling you is, anytime you get ready to hold a board meeting, if you don't have the same secretary, you can appoint another secretary. Just as long as we get the minutes of meeting assigned and outlined right there on this particular minutes of the meeting document, okay? And we got that signed, so we simply add that to what we are doing. Okay. We're not going to be getting into any more of this. When we come back in part 3, we're going to give you an update on what we were actually discussing. We'll get down into the bill of sale. We'll get down into the addendum. We'll be dealing with registry of trust certificates. We'll be dealing with executed and accepted as trustees. Then we'll go on to banking resolutions and this kind of stuff, because this is all a part of a common law trust. There are people who tell me, well, you know, I'm scared of a common law trust. Well, you got to understand something about common law first, and that might make it much more palatable for you. Okay, so if we understand something, and everybody, once again, everybody is on the same page, then we can do some things. But if we're talking about freedom, we want to have every edge that we can possibly have, especially when you're dealing with contract law. I suspect there are quite a few people, and I've heard from quite a few, that have listened to the previous broadcast, especially back in the early days when I was trying to get people to understand the structure of the United States of America and how it functions. Everything functions on contract. But in my opinion, this is a superb contract, and it carries a lot of weight. If you operate this thing, you're operating under protection. You're staying out of the courts. And by the time if something ever goes wrong and you find your way in there, you'll be able to handle that with a piece of cake. As you've heard in the earlier little plug that I ran about, the guy was talking about securities and bonding cases and all this stuff. But in my opinion, before you get to that, you got to know what you're doing. You want to have asset protection. You want to have the structure going. And, of course, we always have to make sure that our family and loved ones are protected. And in my opinion, this is a wonderful way to protect the assets and your children, and being able to leave them a legacy to live by. Now, on part 3 of this broadcast, we're also going to be dealing with the history of trust down through the ages. A lot of them, a lot of us may not have recognized them, but they were real trusts, they was functional, and we was looking at this thing, but we couldn't understand, well, why nothing didn't happen about this, and what happened over there. Well, we didn't know that there were trusts and stuff set up. And so we want to know also how we got in the position to be able to do this in the first place. And so, it all goes back to looking at the history of stuff. Sometimes I have people call me, and they're telling me about, well, I did my nationality, and I done that and the other, and I have to explain to them, well, it's super fantastic. You want to proclaim your nationality. You definitely want to do that. You want to get away from the Afro-American, African-American, Negro, colored, black. You got to get away from all of that. And go ahead and proclaim your nationality. And but when it comes to dealing with the United States of America and commerce, that's contract. And you can go ahead and take control of your straw man, and you definitely want to do that so that you can administrate the operations of this trust from a creditor position. Because, you see, right now, as you're listed on the birth certificate, and I know you probably heard me say this before, you are the beneficiary on that. But you're the lowest person on the totem pole. They're orchestrating your trust, and the state is orchestrating your trust. They are paying for services and stuff that you are receiving benefits from. It benefits you from the garbage man. It benefits you. It's supposed to benefit you from the police, with the police. It's supposed to benefit you to have the highways and bridges and stuff of this nature. However, what about your right? How do we deal when we no longer the beneficiary, but we go ahead and step into the realm of creditor, and we begin to administer our own trust? I mean, you created this bond for us, made us a beneficiary, but we need to be in control of that. And we were supposed to do this when we was 18 years old, but nobody told us. I mean, we didn't get full disclosure. So it is never too late to go back and take control of that straw man and begin to orchestrate that trust yourself. And this is why we are talking about this now, about trust. And, of course, we're going to be getting into other things, but this is just where we are right now. We're dealing with trust. We're dealing with the educational phase. We've set up trust, and we got that function. Now it's time to go to the next thing. And before it's all over, we'll have this done in full swing. But we're taking other people along with us, and that's what these radio broadcasts are designed for, so that you all can become aware of what's going on, so that you can get into this thing and you can protect your family and children and stuff. Learning contracts, setting up your estate, orchestrating your estate, providing protection for your estate and your family. And, of course, we just understood that this thing is set up for 25 years, and that after 25 years, it can be reestablished and go on and on and on. So this is protection that's willable from generation to generation. And you make your children and your grandchildren and great-grandchildren aware of what's available to them and what's going on, so that they can, when it comes time for the renewal, it can continue for their children and grandchildren and great-grandchildren. And this is how this thing is set up. And this is how wealthy people have been doing this for years and years and years. They've been keeping the wealth, controlling the wealth, not owning anything, but controlling everything, and everybody's protected and shielded. So if it's available to us, I think that we should take advantage of it. And, of course, that's just my opinion, okay? And I think it's a pretty good idea. Keep in mind, this doesn't have anything to do with your nationality, because you are more and you're supposed to be able to do this and that. Well, no, let's look at this thing from a whole different angle. I'm a Moor. I was born a Moor. My nationality is Moor. But we study law, we study commerce, and we study this particular game. In order for you to play a game and win the game, you have to know the rules of the game. So this is a wonderful game. We know about football, we know about basketball, we know about tennis, know about golf, we know how to shoot pool, and all these other games. But here is a game that's been around for years and years and years. And now it's a game that you can learn, that you can truly benefit, and not only you, your family can benefit as well. Okay? Now, if you have any questions, once again, 310-982-4184. Press 1 on your phone. That'll give me an indication that you have something to say, and I will open up the phone lines so you can get in. Okay? Hold on.
This is Moorish Talk Live 100. Thanks for listening. We'll be right back.
Okay, before you rush out to save the world, have you made up your own bed yet? Does being a secured party make you invincible? The answer is no. But what are the benefits of being a secured party? Go to www.newdataelimination.com. That's www.newdataelimination.com. Or call me, Tarhaka or Monte L. Bay, directly, 904-303-9061 before 7 p.m. Eastern Standard Time. That's 904-303-9061 before 7 p.m. Eastern Standard Time. You'll be a secured party creditor, but the most important part about all of it is knowing what it is and knowing exactly what to do with it. That's extremely important. www.newdataelimination.com.
These Creditors in Commerce workshop sessions, hereinafter sessions, are the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions, as applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transactions, or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subjects being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, condition upon the fact that this notice is provided therewith. If you have any questions, you may contact Creditors in Commerce by email at harmony@creditorsincommerce.com.
What we're going to do is discuss taking control of property, which isn't what were you trying to file? The reconveyance?
The reconveyance. He absolutely refused to file the reconveyance.
And what was his reasoning?
He just says that he's under Torrens law and he can't make a judicial determination on the owner of the property. And I showed him like the entire, everything that's been done. I said, but
wait. What were you trying to record? Just a reconveyance?
Just a reconveyance.
Are you sure?
Well, yeah, he was going to clear the title of the property.
What's that?
It would have cleared the title, bank from the title of the property.
Right, but it was a proper reconveyance?
Yeah.
And what was defective about it?
He just flat out refused to do it because he knew he was taking the bank off the title. Because he saw my whole process.
Every time someone pays off a house, the deed gets reconveyed.
Yeah, and I had to, he didn't like the, well, he saw me do this.
But you didn't actually pay off the house, did you?
No, I went through the process where
I'm sorry, you didn't pay off the obligation, the account.
Not yet.
Now,
I canceled it, but
and also you were in there as the bank or the trustee, right?
No, I was actually bringing the document. I was basically a courier.
Okay, but was the document being executed by the bank or the trustee? Who was executing the document?
The trustee.
I
had reassigned the trustee.
And who was the trustee?
Just so happens it's my father right now.
Yeah, just some dude's name. They're not used to seeing that. Okay? So, not that they shouldn't have filed it. They filed the substitution of trustee.
Yeah.
Yeah. Okay. So, that's why getting the POA of the trustee, where you can execute the document as the trustee, and then you just mail it into the county, because that's probably how the trustees do it.
They actually use, like a legal courier service.
Okay. You use a legal courier service.
I did. And that's when this guy was like, he shows up to do this, and he goes, they wouldn't do it. I mean, this guy didn't have, he was kind of, I shouldn't say didn't have a backbone, but he's like, well, he didn't understand what I was asking him to do, because it was clearly out of the ordinary. I might be the first person in Minnesota to ever do this, you know? And
so how do you know that the trustees typically use this guy?
I don't.
Exactly. So why don't you just mail it into the county like a trustee would, from the trustee? The thing is, and you said you filed a whole bunch of other stuff on the property?
Yeah, I was
Yeah, they're looking at the title on your house going, oh, there's some crazy shit going on in this property.
Oh, it's
That's
awesome.
why they refused it. That's why I'm saying keep your stuff private. You start filing all this crazy stuff into the county on your property that doesn't look like it should be there. It doesn't have their form. You're hurting yourself. Because let's say you want to sell the property down the line, you aren't going to get title insurance with all those crazy filings on there. It needs to look like everyone else who's cleared their account. Reconvey, and if, now let's go back, because let's say you don't have the time to do a process with the trustee, to get the trustee to grant you a specific power of attorney, to execute the reconveyance and the notice of rescission, but you've already established that you have a specific power of attorney for the bank. What can the bank do? Substitute the trustee. So then you can do a substitution of trustee. Don't use the homeowner name as the new trustee. Okay?
Better to use a trust, isn't it, or some kind of
Or a company with the name trustee in it. Right? Or DBA. Go file a DBA with the county. Mike Smith, doing business as All American Trustees Company. Right? Okay. So, and then once we've done this, now we execute the documents. We execute the notice of rescission if the property is in default or has had a trustee sale, and we execute the full reconveyance of deed. What have we done now? Perfected our title. So now we've settled the account and we've perfected the title. Now, if you've lost possession, now you're going to go about gaining possession of the property. If you're in possession of the property, do you need to do anything about the possession? No, you're in possession. But you need to be mindful of these processes and administrative process in general. This is not for beginners, this process. You need to do a lot of studying to do these processes, because what if they continue to move forward with the foreclosure anyways? You better rebut any presumptions and respond to every step of their process. If you continue to get statements of account, what happens if you hold on to a statement of account for 30 days? Validation of debt. Okay? So be mindful that anything you receive in relation to the account or the title, foreclosure, anything that comes in after you've perfected the account and the title, you better respond. And it better be a meaningful response that rebuts any presumptions that their process is making. Okay? So if you've lost possession and you've settled the account and perfected the title, well, now you're going to give the bank a notice to vacate. 3-day notice. Where are you going to send the notice to vacate to? Nope. This is a public process. Nope. Nope. What's that? You can post it on the property, that's one, but is that sufficient notice?
No.
Who are you going to mail it to? No. If somebody's in the house, you guys don't do this. If they've actually sold it to a family and they're living there, I mean, come on, really? Do another process to regain your loss, okay? But don't go kicking regular people out of their house. I'm saying if the bank sold it to themselves and the property's abandoned, do this. If you guys go around kicking people out of their houses, you're no better than any of the banks. It's not very compassionate. Not to say you don't have a right to, but what you could do is give them notice that they're going to be paying rent to you. Right? So, if they're in fact, because sometimes the bank will rent the property. Right? So you got to establish, look at the title, if it's already gone through trustee sale, see what the latest title documents on that property are. Because if the bank is still the registered owner, then they're either renting it or it's abandoned. Okay? My notice to vacate, my 3-day notice, needs to go to the public side of the corporation. Nobody here knows how to serve the public side of the corporation? What? How do you serve it? How do you serve a corporation?
There's an agent registered with the state.
Ah, Gordon knows. Registered agent. Agent of service, it's also known as. If you go to the Secretary of State records for that corporation, it's going to show you a special name and address of the registered agent or the agent of service.
That's the person who accepts service and every corporation has to have an agent to accept service in that state.
Okay? So that's where you're going to send your notice to vacate. And I would also go pin it to the door. That's if the corporation owns it. Yeah,
yes.
Don't kick families out of home.
Every corporation, yes.
Okay. What's that?
The bank took it back to themselves, sold it to themselves.
Yeah,
They are a corporation.
exactly. They are. Okay, so step 2, after the 3-day notice goes in, and you've waited at least 3 days, 3 days beyond their delivery of it, you want to give them sufficient time to respond, but they only have 72 hours to respond. Then you go file an unlawful detainer or a complaint for unlawful detainer. There's 2 things you must have, 2 witnesses you must bring with you to your unlawful detainer case. What I suggest is go watch a couple of them. There's plenty going on right now. You can sit there for 8 hours in court and watch unlawful detainer after unlawful detainer after unlawful detainer. Go to the court, ask them which department are the unlawful detainers being held in. And go sit there and watch, because every attorney does it the same. There's 2 witnesses. One witness is going to say, and what I would do is write down the questions that the attorney asks his witnesses. Write down the process that the attorney does, and then mimic it. Good afternoon, Your Honor. So-and-so here for the plaintiff. Unlawful detainer on Bank of America. I've got my witnesses. And then you bring your witness up. And you ask the same questions an attorney would ask. On such and such a date, did you serve the 3-day notice? Yes, you did. Yes, I did. How did you serve it? I mailed it to the agent of service. Do you have a record of that? Yes, I do, Your Honor. I'd like to present evidence of the record of service. How else did you serve it? I pinned it on the door. And at what date did you do that? On such and such a date. Your Honor, evidence of service on the door. Then I bring my second witness up. Did you serve the summons for complaint of unlawful detainer? Yes, I did. On which date did you do that? On this date. Your Honor, I'd like to submit into evidence. Actually, that'll already be in evidence because the proof of service must be filed with your unlawful detainer complaint before the hearing. So your proof of service on the unlawful detainer will already be in the case, but you still bring your witness to say, yep, I served the unlawful detainer.
If I have a girl witness, does she have to go, and yes, I did, Your Honor?
Absolutely. Okay, so then what's the judge going to do? He's going to go, bing, bing, and guess what? People have done this. Guess how many times the bank has shown up to the unlawful detainer hearing? 0. So we get our summary judgment right there. Judge goes, okay, I find for the plaintiff. Then you get your writ of possession from the judge. What do you do with your writ of possession from the judge? You take it to the sheriff. You say, I'm kicking Bank of America out of my house. Or out of my house. And they go, you're kicking the bank out? And then they're thinking, I wonder if I could do that. And then a couple days later, 5 to 10 days later, sheriff comes back. Here's the keys to your new house. Thank you very much. And now I've got a settled account, a perfected title, and possession, and thus a perfected security interest. Okay? Now, I may also at that point file some other encumbrance to protect my interests so that it'll predate any and all other encumbrances that may be tried to file on this property. Even though I've already got one in the form of a grant deed, I may set up a new deed of trust. And I may assign a trustee. I'll sign myself as the beneficiary and grantor and appoint Gordon here as my trustee. Maybe not Gordon.
Trust me.
Okay? Seems simple enough? All righty. We're going to take, we have a couple more questions, then we're going to take a break.
Got a mic coming your way. And that was a good point you brought up, Jim, because individuals are not required to have an agent for service in the state. That's only for corporations.
Yes.
Gordon, recently I just went to a seminar where there's a new federal law that was just passed regarding mortgage foreclosures, which stipulated you have to honor lease agreements that's on record, or you have to at least give them a 90-day notice to vacate a property based upon a foreclosure process.
Right.
Is your process, you're going into the public side, therefore are you going to have to abide?
If there's someone leasing the property.
Pardon?
If there's someone leasing the property.
Correct, right.
You're going to give them notice and you're going to be collecting the rent.
Right. If anything in this process must be done in accordance with the statutes of your state. See, I've just given you what I know about California. I don't know how the 3-day notice unlawful detainer writ of possession process works in any other state.
Right, but
I just haven't had the time to do the research.
But there's a new federal law that covers all the states on that 90-day period.
Yeah, which is, in California, there was already a 60-day period.
Georgia's 90 days.
See, in Georgia already had a 90-day.
But you would want to be fair to any tenant anyway. 90 days
if there's a tenant and they're leasing, you want to be fair. And actually, you may not want them to vacate. You may just say, hey, you're going to be paying rent to me in 60 days. Or after I've perfected the unlawful detainer. So you don't have to leave. This notice is for the bank. Right. So when I take possession, you're going to be paying rent to me.
to the perfecting the title, if someone's current on their mortgage, how would you do that then?
Say that again?
If someone's current on their mortgage,
Uh-huh.
they're making their payments,
right,
and they're going to perfect the title, are they going to...
Well, first they have to settle the account.
Okay, they already settled the account. They're at step 2, perfect the title.
Okay, well, you said they're still making payments. That means the account's not settled.
So they stop making payments.
After they settle the account.
Okay, they settled the account. They've been
if they make a payment after the account's settled, then they've recontracted.
Okay, so that's what I want to know. When they stop making, they're not in any foreclosure, they want to stop making payments. After they settle the account and they've done that process and perfected it, then they would not make another payment.
Why would you make a payment if you settle
Because
the account?
some people's jobs would pertain to their credit, and they need to make sure their credit.
Well, they don't believe their process worked then, did they?
Yeah. If that's your concern. Now, if a mark goes on your credit, you got a claim. Because you've got all these look at all the records we've perfected in support of our process at this point.
Do you think notifying the credit reporting agency would be any different for an erroneous thing put on there?
No.
You would provide them your evidence, do a 1, 2, 3 step, and experience the rest of those people also remove that off their credit.
Okay. So you just, okay.
Due
Again,
process with
remember,
them.
this is not for beginners. Okay? Okay, we got microphone. You got a microphone? Okay, go ahead.
Push it up.
Okay. On the specific power of attorney, you're really getting that by default, is that right? Because they are not responding.
Mm-hmm.
Are you offering us some kind of form that we can follow? Isn't that going to look like something kind of irregular?
It's just in the wording of my demand, my notice.
But
remember, I had a, what did I call it? Demand for performance?
Right.
I'm going to have the wording in my demand for performance saying, if you do not perform within said amount of days, you will be granting and conveying to me a specific power of attorney to execute these documents on your behalf. That's it. That is the specific power of attorney.
Right, I get it. But what are the documents that you actually file in order for the reconveyance?
It's called a full reconveyance of deed. And if you're already in default, you're also going to file what's called a notice of rescission. Now, take a step backwards. If you're already in default or there's already been a trustee sale, the notice of rescission goes first.
Okay, got it.
Then the full reconveyance of deed. If there isn't a default or a trustee sale, then it's just a full reconveyance of deed.
And are those documents going to be part of your download package?
No, they're standardized.
There's something that you could look up on the web and fill in the blank. And then when you say file those, you're talking about recording them in the county recorder's office.
Right.
And that is sufficient?
Yes.
Okay, cool.
Absolutely. Because I believe those documents also reference the deed of trust. So you're going to have to reference the deed of trust that you had with that bank. But remember, you're executing on their behalf. So it's going to be in accordance. It should look like any other full reconveyance. If there's a notice of rescission, it should look like any other notice of rescission.
I have a question. I think you lost me because I think you was talking about as if you were in the property, how you would take control of the property, and then it seems like at the end you.
No. Listen, if you have possession, you already control possession. Okay. So you don't have to do anything. You don't have to do an unlawful detainer on yourself. Okay.
So then, in what condition would you do?
Speak into the mic.
Yeah, I can't hear you.
And what circumstance would you do the
Mic's
other
not
one?
on. What circumstance would I do what?
The other one in regards to someone is in the
The
property.
other what? The other what?
That the settlement account, the notice of tender, the notice to vacate, the unlawful detainer, and the writ of possession.
Okay. I'm not understanding the question.
Okay. I guess.
Because you're saying all of these things.
Okay.
You're saying what situations?
In regards to control the possessions.
Okay. This step 3. If you don't have possession, you got to get possession.
Okay.
That's what that
And that
if you already have possession, you already control through possession.
Okay, so if I'm trying to get possession of a property, is that like me driving down the street and seeing a house that I like and...
If it's abandoned. If it's abandoned, yeah.
Okay, okay.
But that's a whole other process because you don't know anything about the account on that one.
Right.
What you would do is you would do a claim, like a private administrative process, where as my brother's keeper and guardian of my community, I see that you're harming my community by having a vacant house in my community. Here's your opportunity, right? Like if I like in in Southern California, there's tent cities where people are living in tents because they've all lost their houses. I can go around to every abandoned property in my neighborhood and take it away from the bank because they're injuring my community and I'm my brother's keeper. And I can give each family in a tent a house. Or I could just look at the records of that property and see who got kicked out of this house. And I'm going to notify them, hey, I'm going to take your property back for you. Give me your account information. Yeah. That's why we're doing the Mastery in Commerce course. Because I can't go around saving everybody. But if I got 100 people doing this, we can save some people. What's that? Amen. Hallelujah. What's that? No, it's a 7-month program. Maybe, well, next year I will be doing it all over the country. Well, actually, not I, but all the graduates of the Mastery in Commerce from this year, we'll be doing it all over the country. We'll be doing 7-month programs in Atlanta, New York, Florida, Texas, Ohio, North Carolina. As long as I get 50 people to show up, we'll be doing it everywhere. And I volunteer to do Hawaii.
Okay, Brandon.
I'd like to have a 7-month vacation in Hawaii.
Okay, just be patient with me because I'm a beginner on this one.
I try to be patient with everybody.
Okay. Now, I totally got lost, but what I was trying to accomplish was A4Ving perhaps, my mortgage account.
Mm-hmm.
That's it.
What do you mean that's it?
Because that's what I thought that you had to do to A4 to settle the account.
Right. So you're only going to settle the account and you're not going to perfect the title.
Well, I don't know. I thought that it's...
Well, okay, you can go ahead and settle the account, but ask the people around you who have already done that.
It's not going to get you ownership of your home.
See what their experience has been about the rest of the foreclosure. Because it just keeps on going. Even though you settled the account, the bank's going to continue to move forward with the foreclosure process.
If you don't want to have problem with your home and you want to maintain it, you're going to have 3 parts that have to be attended to, is what he's telling you. You can't just do this one. You're going to need to perfect the title. And if you don't have, well, you got to control possession, whether you're currently in it or whether you're going to have to go through the process to obtain via unlawful detainer, etc.
So if you're not in foreclosure and all you just want to do is just...
Then you still have to do these 2.
You have to do 2.
You have to settle the account and you have to perfect the title. Because if all you do is settle the account, they still have an encumbrance on your property and they're still going to move forward with the foreclosure process. So yeah, you settled the account, but in 6 months, you're going to be on your ass in the street.
Why would they be moving forward with the foreclosure process?
Jack? Why would they move forward with the foreclosure process?
They're not going to make it simple for you. It's not going to go down that way. This is not, again, a process for amateurs because there's a little bit of process to it. And if they made it easy, what do you think would happen? Wouldn't everybody just do it? And what would anybody learn? For all of you to learn this, you're going to have to elevate your enlightenment to some degree, including but not limited to being a creditor type. This is not for debtor types. This is not a process for you to get over. This is a process to understand, internalize, and then manifest itself in a genuine love for your brother when you do this. So this is what part of what you're being taught here is to become a creditor, which is attitude. And if your attitude is correct, then you're going to desire to learn. One, you're going to settle the account. Why can't I just settle it? Why do I have to go perfect the title? Because it's part of the game.
I don't mind. I just didn't understand if I'm not in that situation, but I do want to gain peace. I could see that coming down the road.
But do you understand now, though?
If you want peace when you're home...
Now that we've explained what's going to happen after you settle the account, do you understand why you would do perfecting the title?
I really don't fully understand what happens. I mean, because you set off, you got a
if
zero
you don't
balance.
perfect the title, you have an imperfect title, and you will not have the home.
Okay. Let's say you settle the account, right? If they move forward and they do the reconveyance and they do the notice of rescission and everything else, then you got nothing else to do. However, don't count on it. As a creditor, you're moving your remedy. You're not sitting back waiting for someone else to do your remedy for you. Right, and if they keep sending you statements, you think they recognize that you settled the account? Right. Now let's say all of a sudden your statements stop after you settle your account and you get a notice of reconveyance. Perfect, it worked. But again, don't count on it. Well, I'm going to put these up on the wall if you want to copy them. Go ahead.
In regard to
you guys are cutting into my dinner time. So
the gentleman, when he was saying he was trying to file some paperwork and they wouldn't take it, I had a familiar experience when I was filing paperwork with the county, the Register of Deeds, and they wouldn't take my paperwork, and so I came back and I sought some advice. And if you put it in under an exhibit, which when I went back and I put it in an exhibit form.
Whoa. What were you trying to file?
I changed the title on the home.
In what form did you change the title?
Through administrative publication, let it cure for 30 days, which I'm changing my process.
Okay.
But this process did work.
Okay, now he's telling you how to get things recorded that you don't want recorded, right?
Well, that's true.
Just so you know, this is how you record things that you don't want to record. Because in reality, the only things you should be recording in this whole process are, if you're in default, a notice of rescission. If you're not in default, if you're in default, or whether you are or not in default, a full reconveyance of deed. That's the only two things that are getting filed. Or if you're going to substitute the trustee, a substitution of trustee. That's it. Those are forms that every county recorder is used to seeing. Don't try to record your administrative process into the public record. You're negating it.
It wasn't the administrative process. We had actually changed title into a corporation name, and we were recording a new deed.
So you're recording a grant deed?
A new deed, that's correct. And still they didn't want to do it, and we had to ask for the supervisor, and then the supervisor came, and at that point they did it.
You need to check they have a book on the forms and the things, and oftentimes a lot of people leave out the standard stuff that's required in their form, and you'll find that if it comports exactly as required, you probably won't have any trouble. And I couldn't tell you if that exactly comported with what their local book requires or that county requires, but when you actually go get a county book for that particular county and see what's required in those, and go perhaps even pull out a recently filed one from some bank, you may find that yours is a little different and might require a little bit of, because they're not going to stop the filing of a new owner, of a grant deed, or a quick claim interest. That doesn't make any sense.
No, and you're correct, because it had to be on the right size paper and form, and so there was all that involved.
All right, go ahead.
At what time, or at what point prior to the perfected security interest or after, do you think that there would be any risk of, like, say, the bank retaliating and suing you and bringing it into the judicial process? Or have you had any experience with that?
I haven't seen them.
So as long as you're just following this, then...
Now, I'm not saying they won't, but if they do, are you worried? We know how to operate on the private side of the court, don't we? And you've got a pretty complete record, don't you?
And that's going to get submitted to the judge in chambers, isn't it? We went through that earlier today, and again, this is not easy for you all to assimilate so much data, but as you pick up the tapes from this particular session and go over it half a dozen times in meeting groups and practice some of this stuff, you're going to get very proficient at it.
My question is, say for instance, I lost the property, it got foreclosed, got taken 3 months ago. Is there a certain period of time that lapsed where it might not be worth it to go back after the property? Even if, say for instance, the bank took it back, it's there vacant.
I would say, is there a family in the home?
No, no
if
family.
It's still abandoned, go after it.
Okay.
It was 10 years ago. If it's been abandoned for 3 years, it may be, you may not have to do any of this process. You could just say, hey, I'm taking this abandoned property. It's been abandoned for 3 years. I shouldn't have said that.
Well, yeah, but no, the key.
That's beyond this group.
No, the whole point of what I'm trying to just wanted to get is that understanding the process that you just outlined.
Right.
Of saying, hey, you know what? I just lost this property a couple of months ago, or whatever the case may be. I just wanted to confirm whether there's a time frame that it makes sense or maybe doesn't make sense to pursue going after the property, especially if the property has not been, no one's occupying the property.
Well, if you're concerned about statute, which I'm not, but if you are, you may want to look at what's the redemption period for your state. Some states have a 3-year redemption period. Some states have a 1-year redemption period. Some states have a 3-month redemption period.
Okay. Just want to know if you're familiar with anything around that. That's all.
Yeah. Okay.
If I have MERS on my warranty deed and I have another company sending me a letter saying they're my new mortgage company because the previous one is in bankruptcy, in my perfection of title, who am I sending my presentment to? My certificate of non-response. Which CFO is getting it? Is it MERS or is it?
He's saying he's going to send his certificate of non-response to somebody.
That's what I heard.
A copy of it.
Come here. Come here.
Come on, Rourke.
Are you really going to send your certificate of non-response to anybody?
That's your private record, Rourke.
Did I use the wrong word?
Did you?
I'm still thinking about the question.
Did you not ask who you're going to send your certificate of non-response to?
Who are you going to send your presentment to?
Yeah.
Oh, okay. Who's the relevant party?
MERS.
Are you sure?
I'm not. That's why I'm asking.
Okay. So you're saying MERS is named as what?
They're on the warranty deed.
As what? If it's MERS, chances are they're a nominee.
Oh, they are the nominee lender.
Yeah, or nominee beneficiary.
Okay.
So
nominee beneficiary.
We're not concerned with nominees. They have no interest. Right?
Right.
So we're concerned with who's got an interest on the property. Okay? Yeah.
The new company says they're the servicer.
Okay, so they're a servicer. Who's going to... Now, not to say you shouldn't give them notice because they are a nominee, but in reality, the bank still has to... the servicer should be included in the process. If the servicer is not who the obligation is actually owed to, you're going to be doing your process with the bank that is supposedly has the interest in the property. But if there's a separate servicing company, you're going to be giving them notice of everything you're doing with the bank. Okay?
So I A4V to the IRS the mortgage, and I send a presentment to Washington, and I have a certificate of non-response from my notary and that presentment to the IRS, correct?
Right.
And then when I send the letter to the CFO, why am I not including a copy of that certificate of non-response?
You are.
So why was I getting rebutted on my sending my certificate of non-response to the CFO?
Because that's all you said, was you were sending a certificate of non-response.
Oh, I got too busy with the question when I didn't
No,
finish
that
it.
is...
In my presenter to the CFO, in which it does include the certificate of non-response from the IRS.
Yeah, and it's a copy.
Yeah,
it's
so
a
I
copy,
was 50% right and 50% wrong.
And it's only one tiny part of the record.
Yeah, right.
Okay. So, yeah. So, you've escaped punishment. All right. We're going to wrap for dinner. And
all right, Mose, we back. Now we're coming down to the close of the broadcast, and I hope you all have gotten something out of this. We will be back with part 3. We're going to be dealing with the bill of sale, and all this is information that we're putting out here to unite. It's the actual construction of your trust, and the best possible trust that you can actually put on paper and file that gives you protection all the way around, and your children is willable for generations and generations. So what I recommend is that you listen to this broadcast over and over. By tomorrow morning, we will have this up on YouTube so that you will be able to listen to it. You can pause, you can rewind, you can do anything that you want, because this is consistent with what comes along with the package that we have at newdebtelimination.com, the secured party and creditor package. It comes along with your manuals. It comes along with your phone and email support. Also, 2 separate packages for about 15 DVD and CD education that comes in the mail to you, and also your credit repair information that is phenomenal in itself. That what comes along with what we are doing involving this stuff. My job is to make sure that I continue to expose this information so that the people who are actually trying to get free and want to be free and exercise some authority and power in this country, and you should be wanting to do that by now. I mean, after all these years, it's time for you to do some things. So we're putting this information out there for you, and I hope you are getting this stuff, but be on the lookout for our video on this broadcast tomorrow. It'll be up. It'll be on YouTube. I'll be promoting it, be sending it out in your emails, be putting it under different groups and stuff on Facebook so you can listen to this, because it's been some very, very valuable information. I haven't finished bringing the information straight from The Hague that we did this evening, but we will be continuing in part 3. Okay? But anyway, it's time to close the broadcast. I've been your host, Tarhaka Omana Elbe, and until next time.
Blog Talk Radio.
He is the last of his kind. All that remains of a once powerful nation. Some think he is a myth. Some believe he is the chosen one.